On a lot of days, it is very difficult for you to get a short date in your matter. I've talked about it on earlier occasions as well. But one of the days where a very, very long date was given, in the circumstances that it was given, and what we did to get this thing changed. This is a couple of weeks ago. An associate said that the judge is on leave, the reader is giving a very, very long date, about 5 months from today. And I told the associate to take all of these steps. And of course, the reader was saying that I cannot give a shorter date than this. If you want, you can move an early hearing application. But to that also, I told my associate to take these few steps. First and foremost, I told the associate to immediately prepare by in writing only. Don't type it out, because that will take up a lot more time. You'll open your laptop, you'll type all of this out, you'll find a printer somewhere, and then the whole process will take about 30 to 50 minutes. Around the time that the reader is giving out the date, or maybe just 5 to 10 minutes into the reader having given the date, you immediately move a written application along with ₹2 court fees on that application. Move an application for urgent hearing and tell the reader साहब इस application को keep it tomorrow only. And what the reader will do, or the other court staff present, especially in district courts, these district courts over here, district court will do is that they will specifically, deliberately say, no, bring this application tomorrow. We will put it up tomorrow. And I told my associate this will happen. But if you agree to this and you bring it the next day, what is going to happen is that the court staff is going to tell you that now we don't have the file with us. So you give us the application. We will trace out the file, we'll give it to the Elmad to trace out the file, and then we'll put it up after a week or two. And they just delay it and drag it on, and there will be multiple visits required just to get the urgent hearing application listed before the court. And that is why you tell the reader that no matter what, I don't care. You are giving me a long date. Today itself, when you have your file with you, I am moving this urgent hearing application. Please take it on the record and give me a date for, tomorrow or day after, या फिर 3 दिन बाद, whatever is convenient to you, but I will not budge. When the reader sahab listens to all of this, they reluctantly take the application, and then they will put the matter before the judge on the next date or the next to next date, the next day itself. Now, here also you need to remember that when the matter is put up before the judge, the main matter which was supposed to be argued, that will not be argued at that day. What will be argued is only your urgent hearing application, where whatever you have agitated, whatever your reasons are demanding urgency in the situation, only that will be taken up. And even then the judge will say, all right, I am issuing notice in this urgent hearing application to the opposite side. And then a date of maybe a week, 2 weeks or so is given, on which date the counsel will appear. And now technically the application is only listed for the urgent hearing. So, if the judge is angry with you, the judge can say, I'm only going to decide the urgent hearing, nothing else. And the counsel can also, if they want to delay the proceedings, say, this is only for urgent hearing, the application, it is to be decided, not the main matter, which is anyways posted for 4, 5, 6 months from the, from the last date of hearing. But sometimes if the judge is on your side and the opposite party also does not vehemently oppose this, you can also take up the matter for arguments on that very day itself. In any case, it's a gamble. Take that risk. And say, for example, if the judge says no, this will be heard on the next date of hearing, but at least the judge will give a short 5, 10, 15 day date. And if you are very, very lucky, then the judge can hear and dispose of not just your urgent hearing application, but the entire matter itself, which was, earlier a date of 4-5 months was given. This does not work every single time. A lot of times judges also get upset and they dismiss your urgent hearing application as well. So you need to see if there is actually a very big urgency in your matter. If that is the case, then you also mention those grounds of urgency in your urgent hearing written application itself. There's a very long video just to talk about urgent hearing application, but those brothers and sisters at the bar who know that they've suffered long dates and no accommodations by either the judge or by the court staff know that this is something that might be of some use. Now, in this particular matter, from the month of May, the date was given of somewhere in September. We were able to effectively, after all of this, we were able to get the matter listed today itself for final arguments after a date being given by the judge, after allowing that early hearing application. So the whole process took about 3 weeks, but we were able to effectively get the matter heard today. Outcome, the matter is fixed for orders at 4 p.m. No clue what's going to happen, but at least we were able to get the matter listed for early hearing successfully. Takeaway for anyone who may benefit from it.